Hi everyone, in this week's dispatch video we are discussing a query that's come in from one of our clients this week around fast tracking a disciplinary or performance process. So the context is essentially that there is obvious wrongdoing, perhaps an admission on the part of the employee, and the question is whether or not the business has to go through a formal exercise in order to constitute a warning or even dismiss. The obvious answer is that we have procedures in place to manage disciplinary performance, and to convolute or avoid undertaking those processes altogether could open up the business to some level of risk. So we have not only our internal discipline and performance management procedures to consider, which we'll talk through, often investigation, bringing an employee to a hearing, allowing representation, and a right of appeal. But we also have the ACAS Code of Practice on discipline and grievance procedures, which applies to both misconduct and performance issues. And again, tribunals are entitled to take into account not only the employer's contractual procedures, but also the code in determining the fairness of a dismissal. So if, for example, we had an instance of misconduct where we decided to issue a final written warning, perhaps because the employee had made an admission that he'd done something potentially dishonest, by way of example. If we don't properly constitute that warning and we subsequently dismiss for a repeat offence or for another issue of misconduct relying on that final written warning, a tribunal may well take into account the fact that there have been procedural failings previously. Similarly, if this was an act of gross misconduct, so in the employer's mind, the employee's been caught by 5 witnesses punching somebody in the face, if they instantly dismiss without a process, again, the tribunal can take that into account when determining the fairness of a dismissal. And the test for unfair dismissal focuses on, firstly, the fair reason relied on by the employer, but then whether a fair procedure has been followed. So that's before we get into the proportionality of the dismissal. The claim could have already been lost by that point, and the employer is then scrambling round to try and limit the damage of a finding of unfair dismissal. So what happens where an employee agrees that the employer can proceed to issue a sanction without any investigation or disciplinary exercise, for example? That does give the employer more flexibility. If we have that commitment which is freely given, perhaps in writing, and the employee saying, I don't want to go through a hearing, please just decide the matter, it does become lower risk to issue a sanction in those circumstances. I would consider whether any additional investigation needs to be done. So do any witnesses need to be interviewed, any CCTV gathered? We should ask the employee if he wants to put any submissions to us prior to making a decision, because remember, we may have the act of misconduct and the admission from the employee, but we also really need to understand any mitigation which might have caused the employee to act in that way, or which may affect the sanction which we ultimately apply. Crucially as well, I would always offer a right of appeal, because it is often open to the employee to change their mind about that consent and to complain further down the line that they didn't have the opportunity to put forward any representations. So ultimately, safest approach in a misconduct, gross misconduct or a performance case is carry out your investigation, invite to the hearing properly, allow representation, make your findings after the hearing, and offer a right of appeal. In very limited circumstances, you may have that explicit consent from the employee that they've held their hands up, accepted that a sanction will have to be applied, they've exhausted everything they want to say, and properly documented. There might be a commercial risk to take there in proceeding, making it clear in the outcome letter that that was the employee's wish, and offering a right of appeal against the sanction. Hope you found that video of use. If you do need any further assistance on these matters or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.